about how to bring up issues in a case that's been closed. And so what we really need to do is have something concrete to bring before the court. And truly the hardest part of my job and the most painful part is when I believe that an applicant is innocent, but there is no legal way to help that person. That's really the most heartbreaking part.
And I'd like you to maybe expand on that statement that you just made. What can you possibly give us an example of that?
Sure. We had a client who we really wanted to achieve DNA testing for. It was a great case. It was an old sexual assault from the 1980s, and we believed in our client's innocence. We applied. We filed a motion for post-conviction DNA testing. In Florida, that's called a 3.853 motion. The court granted the testing and ordered all of the custodians of evidence to submit their evidence to a laboratory for testing. Unfortunately, none of the evidence in this case could be found. It seemed that prior to the rules about evidence retention that were created in Florida, evidence in old cases was routinely destroyed. And so although we believed in our client's innocence, and although the court had granted DNA testing, there was simply no longer anything to test.
Oh my goodness. That is such a key point. And when I speak about the Innocence Project of Florida, people are aghast when they hear that evidence has been thrown out or destroyed after someone goes to prison for the crime and is supposedly guilty. Is there any uniform guideline that applies to all states about how long evidence is kept after a trial is over?
So that's an area for state law, so it's going to vary from state to state. But in Florida, there are evidence retention rules, and now these kinds of evidence, things that could potentially be tested for biological material, are now routinely kept as per the law. But in the 1970s, 1980s, even about halfway through the 1990s, DNA testing was not routinely conducted. And truly, in years past, we didn't know either about DNA itself or about the application in criminal proceedings. And so really, evidence destruction decades and decades ago had to do more with our ignorance. And now the laws have changed such that if a person is going to go to prison for life, if a person is going to be sentenced to death, because unfortunately Florida is a death penalty state, there are rules that require that evidence be retained.
I see. And there have been many people in Florida, as well as the nation, taken off death row. I think the number nationwide is over 160. So what does that tell us? It tells us that there are people waiting to be executed who are innocent. And it's very, very frightening, especially when you talk about evidence being destroyed. So that has certainly changed. Remarkable with Jamie Bain's case, the man you mentioned earlier who spent 35 years behind bars, his actual evidence was kept. I truly don't understand why. That was a stroke of luck for him. And I often wonder if the evidence is destroyed and that's all there is, then there's not much more you can do. And that's what you were saying before. So is it mostly evidence or witnesses that have died? What other things would cause you to say to someone, we just don't have any options open to us?
Well, the Florida law in post-conviction is fairly specific. The law that governs our ability to file claims in Florida courts after a person has been convicted of a crime is governed by Florida Rule 3.850. And under that rule, a person can, for 2 years, bring claims of ineffective assistance of counsel, claims of newly discovered evidence, Brady or Giglio violations. In these older cases, this timeline has expired, And so we start the clock, or rather the state of Florida starts the clock as soon as a person's case has been rejected by the appellate court. So a person is convicted of a crime, the person is sentenced, and then the person may appeal his or her conviction to the appellate court. As soon as the appellate court affirms that conviction, that starts running a 2-year clock to file this 3.850 motion for post-conviction relief. And so in a really old case, absent new physical evidence analysis, we don't have an opportunity to bring claims under 3.850 unless and until there is something newly discovered.
I see. It's very, very complicated. The taking of a case, especially a very old case, where do you begin? I mean, when I think of Jamie, I know in 8 months he was out, thanks to Innocence Project of Florida, but that was the exception rather than the rule. Wouldn't that be true?
Absolutely.
Yeah, that was quite remarkable. All right, you had mentioned to me when we spoke that you had a prison visit, and you wanted to say something about that. Would you like to share that? Yeah, go ahead.
Thank you. So one of the things about Innocence Project of Florida is we're a nonprofit organization. We're not a huge staff. When I started here, there were a lot fewer people working here. And so we had an all hands on deck mentality. I'd been here 3 or 4 months. It was mid-2015. And the project had a 5-day hearing down in the Tampa area. So we were all going to court. But in the meantime, a client needed a visit. We had some paperwork that a client had to fill out, and somebody was going to have to go to this prison. And it turned out it was going to be me because simply nobody else was available. The only time I had ever been to a prison before this was on a school trip. When I was in school, in an undergraduate, they took me to Florida State Prison and showed me around. I was with a group of people. I'd never been to a prison. I'd never been to a jail apart from that. And so when the project told me I was going to make this visit, I was nervous. And I showed up at Sumter Correctional Institution and walked through a metal detector and showed them my ID. And they led me to, the guards did, they led me to this little room right off the prison yard. And they said, well, go get your client. And I didn't know what to expect or who to expect. But as I sat there with my little body alarm that they'd given me to press in case of an emergency, I waited, and they brought in this really huge man. I was thinking, oh man, this is all right. And I smiled and I shook his hand and he sat down and we had the most beautiful conversation. He told me about the history behind some of his tattoos. He told me some stories about animals that he had had, pets he'd had, and we took care of the paperwork too, but we had a really wonderful visit. And I always had a special place in my heart for that client and that visit because it was my first and because he was so kind to me.
And go ahead. I'm sorry. I thought you were finished. Go ahead.
In January of 2018, I got to see that man, Dean McKee, walk out of a county jail on an appellate bond. And then later on, several months later, I got to be present when Dean McKee was exonerated. The man that I visited in prison, Dean McKee, was exonerated and now owns his own business in the Tampa, Florida area. So to see somebody go from being wearing handcuffs and prison blues to being a person who has his own business, a beautiful home, spouse, beautiful, wonderful animals that he loves, was just such a pleasure for me. And I will never forget that visit. And to this day, Dean has a special place in my heart.
I can understand that. And Dean spent 30 years behind bars for a crime that he did not commit as a teenager. I think he was 16. Is that correct?
That's correct. Yeah. Dean went to prison for life at 16. Yeah. And through Innocence Project of Florida, we are able to see Dean thrive. In fact, the last time I saw him, he gave me a business card for his tattoo studio that he's running. He's a beautiful artist. And I carry that card around with me as a bookmark. So whatever I'm reading, there's his card reminding me of how important the work is.
Oh, it is. It's so very important. And I so often say to people, what price, even though we work free of charge pro bono, what price can you put on freedom? I don't think there is one. I think it's priceless. So that was a wonderful story that you told. And in the few minutes we have remaining, I know you have been at the legislature recently. What was your role at the Capitol? What was going on there?
Something that we're very excited about, along with the Innocence Project in New York and exoneree Nathan Myers. We were at the Capitol talking to legislators about making a change to the law that compensates exonerees for the time they spent in prison. Presently, if a person has a conviction in addition to the wrongful conviction, that person becomes ineligible for compensation. And so Mr. Myers was with us because he and his uncle were exonerated together. They each spent 43 years in prison for a murder they did not commit. And through the help of the Duval County Conviction Review Unit and the Innocence Project of Florida and Holland and Knight, both were exonerated. Now, Nate went to prison when he was 18 years old. He has no prior record. He is eligible for compensation. His uncle went to prison when he was 34, and he had some previous convictions in the 1960s, and then spent the same amount of time, 43 years in prison, as Nate did, but his uncle, Clifford Williams, is not eligible for compensation. And so we were here talking to the legislature about making a change to the compensation law that would allow innocent people to receive monetary compensation for what has happened to them.
I see. And when does the legislature vote on this change in the compensation law?
Well, it's a process. So right now, the bill is in drafting, and what will happen next is that we'll make the rounds to the relevant committees in the House and the Senate. And what we hope for is that the changes that we want, that we advocate for, that Nathan Myers has advocated for, will make it out of committee in the Florida House and the Florida Senate, and we'll make it onto the floor for discussion. So there are some hurdles to cross still,
yes,
but we are optimistic and look forward to testifying on behalf of the bill.
That is great. Speaking of Nathan Myers, I will be interviewing him and the head of the Conviction Review Unit, the new one, and also one of our lawyers for my next set of podcasts. So you kind of good segue into that, Adina. Well, thank you so much. You've really opened our listeners' eyes into just a small window into one of the jobs that goes on in the office in Tallahassee. And in time, I'd like to speak to all the people in the office so they can tell us what they do to help people who have been wrongly convicted and incarcerated. Thank you again for your time. Thank you so much, and hope we will have our listeners come back and join us again at Pursuing Justice. Thank you very much.